right, Alicia, thank you very much for that breaking news from Colorado. We're going to have more on this now.
Let's talk about it with Dan Schorr, who is a former prosecutor, and Chip Merlin, who is a criminal defense attorney. Dan, let me start with you. So, and I got to ask you this first, as someone who does not have a law degree. 24 counts of first-degree murder. There were 12 victims, so that's 2 counts of murder for each victim. Why?
Well, there's 2 theories of murder that they can present to the jury ultimately. One is for an intentional killing, where you intend to kill the victim, and one is for extreme indifference to human life, where you do some kind of behavior that just doesn't care about the consequences. And they can charge either theory, and that's pretty common in different states around the country.
And there were 116 counts of attempted murder, Dan, and we know that there were 58 people who were wounded.
Right.
What does this tell you about the prosecution's case?
Well, this is pretty standard, that you want to present both theories of murder and both theories for attempted murder to the jury so that you can get a conviction on either one or both. The case is pretty strong. We know who did the shooting. We know the consequences of the shooting. We know how planned it was. The only option for the defense is to offer an insanity defense, which is going to be extremely difficult for him to succeed with.
Chip, the only option is an insanity defense?
Well, it would seem to be that way. There seems to be no question that he was the one that did it. And if that's the case, and especially given the circumstances, he was seeing a psychiatrist prior to the incident occurring, and the question is going to be whether or not his mental illness was such that he did not know the difference between right and wrong when he did this. It is a very difficult defense to prove, but it might be his only way out in this particular case.
And Chip, an interesting point that I was reading in some of the notes that we were given is that in the state of Colorado, the burden is on the prosecution to prove that a defendant was sane at the time that he or she committed the act, not on the defense to show that their client was insane.
That's a great point. Under the Colorado rule of evidence, all the defendant has to do is show some evidence of insanity, and then it switches back to the prosecution to indicate that the defendant indeed was sane at the time these acts were committed. Now, it's important to remember that just because you have a mental illness, that's not a get-out-of-jail-free card. You automatically are deemed to be insane. There are millions of people that are seeing psychiatrists and psychologists that absolutely know the difference between being right and wrong. In this case, it is the prosecutions that have to show that he was sane, and the defense obviously is going to have the rebuttal to show that he was insane, but that's not just because you're seeing a psychiatrist that proves that you were insane at the time this happened.
Dan, what about the defendant's competence to stand trial? That's something we saw in the Tucson shooter's case, where he's now getting medical treatment so that in the future he may be able to stand trial. Do you expect to see and hear those kinds of similar arguments from the defense with this defendant?
Well, the defense may raise that. We would expect them to raise anything they can. Most likely he's facing a death penalty here, and they're going to try to throw everything they can at the prosecution, at the court, to try to save this defendant's life. So they may say he's not competent to stand trial, but his actions during the shooting were so precise, so planned. He knew which theater to go to. He shot people supposedly as they were leaving the theater, targeting specific people. He booby-trapped his apartment. So this is someone who really understood, from the evidence that we know, what he was doing and how to accomplish his goals. And that flies in the face of someone who doesn't understand what's happening in a court proceeding and therefore would be unable to aid in his own defense, which is the standard for him to be unable to stand trial.
Chip, what about the possibility of a deal here, a plea deal that I guess would spare everyone from having to go through the trial, but may also keep this defendant from the death sentence?
Wow, that's hard to imagine in the state of Colorado, where you have the death penalty available, and
it's not really used a whole lot. Only one person has been put to death since the death penalty was reinstated there.
I understand that, but in this particular case, a lot will depend upon I think the responses of the victim's family. In Colorado, there's a very strong public policy that their voice has got to be heard, and the prosecutor has already set up a response. So they're kept up all the way through with respect to all the evidence that's being gathered in this case, and certainly with respect to sentencing.
Yep.
They have a right in Colorado to be heard, but we'll see. This is an awfully tragic incident. It's kind of hard to believe that a prosecutor is going to agree to a plea deal, given the gravity of the circumstances.
Chip and Dan, thank you both, and we'll be right back.
Thank you.